Hello, my name is Jeff McDonald and thank you for joining me. Today we are discussing attorneys' unique duty of confidentiality to their clients and ways to ensure commercial cloud storage service complies with that duty. I'd like to start with an overview of my presentation today. First, I'll give an introduction. I'll discuss legal ethics and the concerns as those intersect with technology. Next, I'll talk about related research in the field, attempts to create practical guidance for attorneys to comply with their duties of confidentiality. Next, we'll discuss methods of research and my hypothesis. Finally, I'll talk about the results of my work and opportunities for further research down the road. Like every industry, using the cloud has become a practical necessity in the modern practice of law. It allows lawyers to work from anywhere, share data with other offices, easily update material, and keep off-site backups. Firms can scale up and down with their needs and with little investment. Obviously, there is a downside. Law firms are particular targets for data breaches because they have their clients' sensitive information, but the people in charge of law firms are often not necessarily in the business of technology or security. IT may be a secondary concern for them, which can make law firms a soft target. On top of that, law firms tend to hold their clients' juiciest, most sensitive data, because that's the data that's subject to litigation. This has led to a number of high-profile data breaches. A couple of notable examples include the Panama Papers, which you may have read about. A number of high-profile people around the world had been keeping their money in tax shelters through a Panama-based law firm, and their personal information was leaked on the internet and in the news. There was also a wiperware attack at the international law firm of DLA Piper. Wiperware is software that attempts to delete all records on a system where it's installed. And finally, there was allegations that the Chinese government had attempted to hack the emails of high-ranking attorneys in major U.S. law firms in 2015. Attorneys in all U.S. jurisdictions are bound by a duty of confidentiality to their clients. The American Bar Association Model Rules of Professional Conduct require a lawyer to make reasonable efforts to prevent the inadvertent or unauthorized disclosure of, or unauthorized access to, information relating to the representation of a client. This rule has generally been adopted in every state. The ABA model rules have comments, which give some guidance as to how they are to be interpreted. Reasonable efforts consider factors such as the sensitivity of the information, likelihood of disclosure, cost and difficulty, and how practical it is to maintain while still running a law firm. There's a number of ways that confidentiality can be violated by the use of cloud storage services. For example, the cloud vendor an attorney uses may not consider that information confidential. If this is a vendor that typically deals in things like family photos or social media, they may not use confidentiality when dealing with their client's information. A vendor may not employ adequate protections. Likewise, if this vendor is not as concerned about security, they may use outdated security protocols or no encryption, either in transit or in storage. Finally, a cloud vendor or a subcontractor of that vendor could even be affiliated with an attorney's client's opponent. This would be considered a breach of confidentiality, even if the entity was not necessarily aware that they were holding confidential information adverse to them in litigation. This is still a concern for an attorney who is trying to maintain the right of confidentiality of that material. One case I do want to mention here that deals with this issue, this was before the federal court in Virginia. In this case, a funeral home had burned down, and the insurance company was denying the claim, claiming that it was arson. The insurance company's attorney uploaded the entire case file to a cloud storage service called Box. Now this service had no password. It was just protected by a unique URL that the attorney would send out to his expert witnesses so they could access the file. During discovery, that attorney's law firm inadvertently sent the other side a printout of an email that contained the URL to that Box address. The attorney for the other side checked the URL and found the opponent's entire case file, unencrypted and not password protected, available for download. The court ruled that the attorney who had uploaded his case file had waived confidentiality, and that this was no longer confidential information. That attorney was likely receiving a malpractice lawsuit from his client shortly thereafter. Now, there have been some attempts to create guidance for attorneys on how to use cloud storage responsibly. In 2013, the American Bar Association attempted to create a framework for acceptable cybersecurity practices for law firms. This resulted in the ABA Cybersecurity Handbook. This handbook offers an exhaustive dive into various state and federal regulations that may apply to client data held by a law firm. Unfortunately, the ABA handbook provides little in the way of specifics to guide lawyers in evaluating cloud services. For example, it states if you use third parties like cloud services, take appropriate steps to make sure that they are adequately protect the security of the data you entrusted them. And much of the handbook's other guidance is equally vague. In 2016, the ABA Cybersecurity Legal Task Force attempted to develop a more specific guide with its vendor contracting project. The project produced a cybersecurity checklist. The ABA's European counterpart, the CCBA, issued its own guidance on improving the IT security of lawyers that same year in 2016. Also in 2016, the Legal Cloud Computing Association, which is an industry trade consortium, released its own set of cloud security standards for the legal industry. All three of these guidelines give general considerations for law firms when evaluating contracts with cloud service vendors, but none really give specific items to look for, and none evaluate existing vendor terms of service for how they stack up. The aim of this paper is to use these existing resources and synthesize them into a list of required elements to look for in the terms of service of a potential cloud vendor. To accomplish this, a list of proposed requirements was developed using input from the ABA, CCBE, and LCCA, and updated to the latest technical standards where appropriate. The list was then used to evaluate 4 large business-oriented cloud storage vendors, chosen for their respective market shares. This list includes offering from Google, Microsoft, Amazon, and Dropbox. iCloud was omitted because Apple does not offer a business version of this product. Vendors scored a point for each criterion with which their current end-user license agreement, terms of service, or other customer-facing documentation indicates compliance. Each vendor's points were then totaled into its score. My hypothesis for this project is that the majority of cloud data service providers' terms of service will be in some way non-compliant with the confidentiality requirements. confidentiality requirements change over time with new court decisions and advisory rulings. Cloud vendors market their products to the general public, not just lawyers, and will lag behind in requirements specific to the legal industry. As clear requirements either do not exist or have not existed until recently, the current solution has been for every law firm to decide for itself what constitutes reasonable efforts at confidentiality. These judgments may be influenced by the price and convenience of the service, as well as the technical illiteracy of the attorney. They do not put pressure on cloud storage vendors to meet any certain confidentiality requirements. This table shows the results of the research. For the sake of simplicity, the list of requirements was distilled down to 10, which were simplified a bit to fit in the chart and to give a yes or no answer. Requirements were also selected in part to represent the cutting edge of the industry. I eliminated some basic requirements that everybody complies with. While the spread of scores was fairly tight, Google and Microsoft had the highest scores. Although this was not a consideration in the test, Google and Microsoft also had the clearest and most comprehensive customer documentation. Dropbox offered significantly less documentation, and Amazon's was all over the place. Their cloud offerings were a bit of a choose-your-own-adventure. Because no company had total compliance, there are still opportunities for vendors to increase confidentiality. For example, there was little transparency surrounding third-party contractors' access to client data, or even who those third-party contractors might be. There were a lot of aspects I couldn't cover in this paper. Further research could consider things such as the General Data Protection Regulation, or GDPR. This was a sweeping privacy law implemented in Europe in 2018. It really changed the landscape there. Because this paper focuses on American law, I didn't include the GDPR, but it is certainly relevant to international law. Also, there are a number of smaller cloud vendors that cater to specific industries or needs. Sometimes they handle problems very differently than the bigger general-purpose vendors, and they may merit research unto themselves. Finally, I didn't discuss any proposed changes to U.S. law. This is also an entire paper unto itself, as far as recommendations or where the law is deficient or should be changed. This concludes my presentation. Any questions can be directed to me at jm8234@nyu.edu. Thank you.